For the record, this matter is before the court, subsequent to the parties having conferred, mediated with Mr. Josh Walker from the front of the court this morning. This hearing is being conducted via Zoom. Are you Crystal Cook?
Yes.
You Kyle Williams?
Yes.
It appears the matter was initiated by a motion filed by plaintiff mother seeking modification of parenting time. In any event, the matter was heard, I believe, by the referee Homrick. And the referee Homrick referred the matter to Mr. Walker for mediation to mediate the issues of custody and parenting time, as well as schooling for the 14-year-old child of the parties. In any event, the parties have conferred. Mr. Walker, the parties have reached an agreement. Is that correct?
Yes, Your Honor, they have.
Okay, the court has received the following recommendation from Mr. Walker, is that the minor child shall attend homeschooling with the mother. No change of custody or parenting time. Is that correct, Mr. Walker?
That's correct, Your Honor. The only thing is changing is school.
All right. All right, Ms. Cook, do you understand the recommendation this morning?
Yes.
And is that your agreement?
Yes, I'm fine with that.
Okay. You understand we're not modifying custody or parenting time this morning?
I do.
Okay, Mr. Williams, do you understand the recommendation this morning?
Yes.
You agree with that recommendation?
Yes.
Okay, you understand that we're not modifying custody or parenting time?
Yes.
At least not at this time. It could be, it's always open to the future. All right, Ms. Cook, Mr. Williams, can you both please raise your right hand to be sworn,
Yes.
please? Thank you. Ms. Cook, do you believe this agreement and recommendation is in the best interest of your son?
Yes.
Same question to you, Mr. Williams. Do you believe that this recommendation and agreement is in the best interest of your son, Corey?
Yes.
Do either of you have any questions for Mr. Walker? Any questions for the court?
No.
No.
Okay, and obviously, Ms. Cook, you want to share information. The two of you have joint legal custody, so share information regarding Corey's schooling with Mr. Williams. And obviously, Mr. Williams says to the extent you can participate in that schooling in terms of homework, reading, other assignments that will benefit your son. So the court would encourage that. Very well. The court finds agreement of the parties to be in the best interest of the minor child. The court will accordingly adopt the agreement, enter the order that the minor child shall engage in homeschooling with the plaintiff mother. And obviously, you have a state curriculum. Is that correct, Ms. Cook, that you will follow with this homeschooling?
Yes.
Okay, and obviously, keep Mr. Williams informed of, I don't know if does Corey receive, is he graded at the end of a completion of a course?
Yes, he will be graded at the completion of a course.
Okay. Well, obviously, you should inform Mr. Williams of those results and those grades so that he's aware if, in fact, Corey needs some additional assistance, some additional tutoring, whatever. The two of you should be able to discuss that and agree upon that. So please communicate for Corey's best interests.
We will.
All right. And Mr. Walker, anything else that should be addressed this morning?
Your Honor, I believe that covers everything.
All right. All right. Thank you, Mr. Walker. All right. Well, good job. The court applaud you, Ms. Cook and Mr. Williams, for reaching ultimately your own agreement in terms of what's best for your son. You know better than anyone in this world what's best for Corey. So continue to communicate for his best interests. The court will adopt this recommendation, copy mailed to both of you, and that will conclude this hearing. Good job. Okay, both zoom out. Have a good rest of the day.
You too.
Thank you.
For the record, this matter is before the court for a continued pretrial conference. The same is being conducted via Zoom. Present is Attorney Anthony Bruskel, representing the plaintiff, Andrew Pease. Mr. Pease appears to be present with Mr. Bruskel. In addition, Attorney Maria Zagorski is present representing the defendant, Amber. And Ms. Amber is present with Ms. Zagorski. Good morning.
Good morning.
Good morning, Judge.
And Mr. Bruskel, Ms. Zagorski, what's the current status of this matter?
Your Honor, I believe the parties are going to attempt reconciliation. It's my understanding that we're going to enter a stipulation to dismiss without prejudice to give them a period of time to try to reconcile. And if they cannot, they're going to let their attorneys know, and we're going to put together a global resolution to submit to the court as a final judgment entry along with a stipulation to enter that judgment, if that is agreeable to the court.
Wonderful. That's good news. Ms. Gorski, is that correct? Is that also the intent of Ms. Pease?
It is, Your Honor.
Well, Mr. and Mrs. Pease, it's worthwhile making another effort to preserve your marriage relationship of 10 years. You obviously brought 3 children into this world. So the court certainly applauds your willingness to at least to continue efforts to maintain the marital relationship. Who will prepare the stipulated order? Mr. Breskel, will you prepare that, submit that to Mr. Gorski?
I will, Your Honor.
Okay, and of course, the court's position is, at least it stops the clock. Actually took the proofs back in June. If the court would allow the case to be reopened upon filing of a motion, I would just ask that the parties perhaps schedule mediation with Mr. Walker prior to scheduling that motion to reopen this case for hearing.
Of course, Your Honor.
All right, do either of you want to voir dire your respective clients on the record this morning?
No, Judge.
No, thank you, Your Honor.
All right, thank you, Mr. Breskel and Ms. Gorski for supporting the efforts of your respective clients, keeping the communication open, and the court is pleased to enter that order of dismissal without prejudice upon receipt. Good luck, Mr. and Mrs. Pease.
Thank you, Judge.
You're welcome. All right, that will conclude this matter. Zoom out. Have a good rest of the day.
Thank you.
Thank you, Your Honor.
You're welcome.
Thank you very much.
That couple, remember they're hearing impaired.
What's that?
Remember that couple?
Oh,
I
that's.
forgot just
them.
to stop slowly.
Yeah,
I was thinking, a lot of times they seem to get older. You just don't hear your spouse. You hear, but you don't listen. Would you- What'd you say?
Ellen always says that I mumble. I'm like,
I know.
needing hearing aids.
I sure I did the same thing. What'd you say?
What does this come out of?
You're talking as you're walking upstairs.
Yeah.
Can't hear you.
We do that all the time. So when he says what, I go, what? And I just say it back to him and it gets him. Where does this come out of? Oh, here it is. All of a sudden I didn't have a.
I texted Tom Scott this morning. He's a neighbor too. It was about 6:30. And I said, Tom, there's a raccoon on top of your birdhouse. Of course, he's got Martins.
Oh, does
Martins
he?
coming from Brazil. He's got 3 houses. And of course, this obviously he's going after the birds or the eggs. And how do we get up? It's a Martin house. There's a pole. Obviously screwed up there. I said,
Was there
Tom,
really?
shoot that raccoon. So I see him come out at 6:30. He's got a hose. I said, Tom, we wanted to check your marksmanship if you can still fire that firearm. He said, I don't want to wake up the neighbors. But yeah, I woke up and I see this thing. I think, is that an eagle or a hawk? It said something perched on top of the birdhouse. And I got the binoculars out and sure enough, it was a raccoon that was sitting on top of the birdhouse. No, he had a he went up a pole. I didn't realize he could climb a pole.
Because you think you'd slide down it.
Is it a wood pole?
No, it's metal. Yeah, metal. He was able to get up. Yeah, this must have wrapped his feet around and climbed up the pole. So Tom got the hose out and he jumped off.
I would want to see who's gonna ring camera. Because that would be interesting to see how he got up there.
Yeah, because that's slippery.
You watch those videos of those squirrels trying to get up on it.
Mhm. I know. And they can't.
You
It's
almost
almost
feel bad for them.
I know.
They try so hard.
like, I just want to know.
Okay, good. And I think Clark stopped on that, but anyways, we'll get a order of dismissal be submitted. And that's always a good. For the record, this matter is before the court for a pretrial conference, the same as being conducted via Zoom. Court is in receipt of a form judgment divorce, which occurs been signed by the parties, but it's blank. Nothing's been completed.
No, Your Honor.
Are you John Johnson?
Yes, Your Honor.
Hey, Mr. Johnson, we sent you the judgment and we put a stick note, highlight in yellow. I'm not sure what more we can do and say, you have to complete this, then sign it, then return it. What
You are right, Your
more
Honor.
can the court do to explain to people what they need to do? I'm just wondering for future.
No, you're absolutely right, Your Honor. We live far apart, and I signed it and sent it to her, and we haven't had that much communication, and she didn't realize she was supposed to fill it out, and we were not able to meet, and I was not able to get to her to get a new one and get to her and get it completely filled out before today.
Okay. We have to address everything, division of property, child support, custody,
there is no-
parenting time.
Well, me and her have talked a little bit, and I'm willing to give her what she wants. She would like full custody.
Okay, well, I'll walk through this with you. Are you Alexandra?
Yes,
Hello,
sir. Yes,
Right.
sir.
So You've been married 8 years, but you've been separated since 2017. You only lived together as husband and wife for 1 year. Is that correct?
Yes.
Okay.
Yes. We
so
tried to
let's
do
walk-
this divorce one time.
Okay, let's try to walk through these issues with you. If necessary, you can talk at the front of the court if there's anything in dispute. You have one child.
Yes.
Typically, we address the parties' parents should share joint legal. What joint legal means is that two of you share equal in any major decision concerning the welfare of your son. For example, he needs elective surgery. Both of you should agree upon that. Schooling, things of that, major decisions. Can two of you communicate regarding the best interest of your son?
I'm asking for sole custody. He has not been.
Hold on. There's two things. There's legal custody and physical custody. We don't get caught up with physical custody. It's just legal and then parenting time. So can you agree upon
Right.
joint legal?
Yeah, I would.
No.
I would want full legal, all of it for sole custody for me.
All right. And Mr. Johnson, do you disagree with that?
I do not, Your Honor. I'm willing to give
All
her
right.
what she wants.
So I'm going to indicate that the custody, legal and physical custody is warranted to the plaintiff. I'm sorry, the defendant mother. Is that correct?
Yes.
All right. So I want to complete this, Judge. I'm going to put my initials next to every box I'm checking. Is that agreeable?
Yes, sir.
Yes.
Okay. So I'm going to indicate that custody of the minor, legal custody is awarded to defendant mother. Physical custody is awarded to defendant mother. What about parenting time? Do you want to we can put either reasonable or liberal, whatever two you work about, or we can put a specific parenting time schedule for dad?
None.
No, sir. Yeah, she doesn't. We've talked enough where I'm going to walk away, sir. She
You
don't
can't
want
walk
nothing
away. I
from me.
mean, Jace has a right to have a relationship with each parent. So I'm going to put in reasonable liberal. So if you don't request parenting time, Mr. Johnson, so be it.
Okay.
And if in fact there's an issue down the road you want, you can always petition the court for a specific parenting time schedule.
Yes, sir.
Okay, so is it agreeable to court with reasonable liberal?
I agree.
Is that agreeable, Ms. Hillebuck?
Yes, sir.
As required by law, I'm going to check the box that the domicile child shall not be removed from the state of Michigan without approval of the court. So you can't move to California without Mr. Johnson's approval. You can move it. You can't take child with you unless you get Mr. Johnson's approval or the court's approval.
Yes,
Okay?
sir.
So we'll check that box. Parenting time, reasonable liberal. Spousal support, known as alimony. It's more for long-term marriages and people that are older. Both of you seem to be young and able. So can we agree that spousal support is not awarded and it's forever barred?
Yes, sir.
Absolutely.
Personal property. Have you already divided your personal property?
No.
We have nothing to divide. We don't have nothing together.
Okay. Well, so I put in the judgment that each of you is awarded the personal property occurring in your possession, free and clear of any claimant part of the other. Is that correct?
Yes.
Yes, Your Honor.
Okay. Joint debts.
No, Your Honor.
Okay, so I'll say put that each party will have any debts in their own names. There are
Yes, Your
no
Honor.
joint debts to be divided. Motor vehicles. Each will keep
None.
their own automobile, free and clear of any claimant part of the other. Is that correct?
Yeah, we have zero things together, Your Honor.
You, no real estate, correct?
No.
Correct.
In your own name.
I'm sorry?
Do either of you own real estate in your own name?
No.
All right. The court will check the box. The party do not own real estate, no real estate to be divided. Retirement benefits. Each will keep your own, free and clear of any claimant part of the other, whether it's an IRA or pension or 401k, correct?
Yes.
Yes.
Okay, the court will check the box that each party is awarded their own retirement benefits, free and clear of any claimant part of the other. Ms. Heilebuck never took the name Johnson, so we don't need to change her name. Okay, the only issue that needs to be addressed is that of child support. We either, so I'm gonna, we talked about child support, the court we either set an amount or we put it, it's reserved.
Can
We
we
have-
put it reserved, sir? Because I'm not asking for any child support.
All right, is that agree with that, Mr. Johnson?
Yes, sir.
Mr. Johnson, is that agreeable?
Yes, sir. Yes, Your Honor.
Okay, I'll check that the box, child support is reserved. In, obviously, you can always petition for child support at any future date and time, Ms. Heilebuck. You understand that?
Yes, sir.
Okay, it appears that we've addressed everything. All right, can you both please raise your right hand to be sworn? 111, correct?
Yes, yes, Your Honor.
Mr. Johnson, is it true that you filed a complaint for divorce with this court on or about April 19th, 2024?
Yes, Your Honor.
Is it further true that on the date you filed the complaint that you've been a resident of the County of Monroe, State of Michigan for at least 6 months?
Yes, Your Honor.
Is it further true that you married Alexandra Heilebuck on August 15, 2016? You separated in July of 2017.
Yes, Your Honor.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed and there's no chance of reconciliation?
Yes, Your Honor.
Is it true there's just one child born during your marriage, namely Jason?
Yes, Your Honor.
Do you have any questions for the court?
I do not.
Thank you. Ms. Hellebuck, can you please state your name and current mailing address for Thank you. Ms. Hellebuck, did you hear the testimony of your husband, John, this morning?
Yes, sir.
Was his testimony true and accurate?
Yes.
Are you currently pregnant?
No.
Is it true there's only one child born during your marriage, namely Jace?
Yes.
Do you have any questions for the court?
No, sir.
All right. Court has completed the judgment. I put initials in every box I've checked. Per your agreement, the court would encourage Mr. Johnson to have a relationship with your son. You owe that to him. You brought him his word. You owe that to him.
Yes, Your Honor.
So in any event, however, based upon the testimony that's been presented this morning, as well as the complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties be and is hereby dissolved and judgment shall enter, granting a divorce and bonds of matrimony. The court has signed the judgment, a copy mailed to both of you. Now we'll conclude this hearing. You can both zoom out. Have a good rest of the day.
Thank you. You too,
Thank you,
sir.
Your Honor.
For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Present is Attorney Kimberly Kuhn, representing the plaintiff, Jason Shepard. In addition, Attorney Kirsten Nimick is present, representing the defendant, Melissa Shepard. Good morning, everyone.
Good morning, Your Honor. Good morning.
Mr. Shepard, the parties did mediate with Ms. LaPrade this morning. The court's understanding is that they have scheduled a continued mediation on September 20th at 8:30. Is that correct?
That is correct.
Can we take the proofs this morning due to the stop the court's clock, so to speak? Any objection?
I haven't discussed that with my client, Ms. Shepard. Taking the proofs just means that we would establish the jurisdictional proofs and that there's been a breakdown of the marriage and that there's no chance of reconciliation. You are the defendant in this matter, so you wouldn't necessarily have to do anything other than agree. Do you have any objection to taking the proofs this morning?
No.
Okay.
All right. All right. The Michigan Supreme Court sets timeframes for courts to move cases, and I don't think cases should be pushed along, and the parties should be able to take their time to work through issues. So by taking the basic testimony this morning, the court will reserve all outstanding issues. And then the schedule is for a continued pretrial conference after the September 20th continued mediation. All right, Mr. Shepard, can you both please raise your right hand to be sworn, please? Ms. Quinn, if you can give with Mr. Shepard, please.
Thank you. Jason, can you state your full name for the record, please?
Jason Matthew Shepard.
Jason, were you a resident of the state of Michigan for 108 days and 10 days in Monroe County immediately preceding the filing of the complaint for divorce?
Yes.
Was your wife a resident of the state of Michigan for at least 180 days and at least 10 days in Monroe County immediately preceding your filing of the complaint for divorce?
Yes.
Were you and your wife married in Monroe, Michigan on May 25th, 2002?
We were married, yes, but it was actually in Toledo.
So you were married in Toledo, Ohio on May 25th, 2002?
Correct.
Okay. Is it true that there were no minor children born of the marriage?
Correct.
Is it true that your wife is not pregnant?
Correct.
Is it true that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and that there remains no reasonable likelihood that your marriage can be preserved?
Correct.
You're asking that the court grant your complaint for divorce and reserve all other issues.
You broke up a little bit.
You're asking that the court grant your complaint for divorce and reserve all the issues concerning property.
Correct.
Debt. Okay. No further questions.
Thank you, Ms. Kuhn. Ms. Nemec, do you have any questions of Mr. Shepherd?
I do not. Thank you.
If you could just confirm with Ms. Shepherd, she's not now pregnant, please.
Melissa, can you state your name for the record?
Melissa Shepherd.
Did you hear all of the assertions Mr. Shepherd just placed on the record?
I did.
To the best of your knowledge, were they true and accurate?
I'm not certain what his residence was prior to the filing.
But your residence was in Monroe County for at least 180 days prior to the filing?
Correct.
And I should clarify, in the state of Michigan for at least 180 days, the county of Monroe for at least 10.
Correct. Yes.
Are you currently pregnant?
No.
I have nothing further, Your Honor.
Thank you, Ms. Nemec. Based upon the testimony that's been presented this morning, as well as the complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the obvious matrimony had been destroyed, and there appears to be no reasonable likelihood of reconciliation. At this point in time, the court will simply resolve outstanding issues and order that the parties appear back before the court for a continued pretrial conference subsequent to the September 20th, 8:30 a.m. mediation with Ms. LaPrade. Mr. Richard Shepherd, you're both represented by two capable, experienced family law practitioners, making sure the best resolution is one in which you both participate and ultimately reach your own agreement on, as opposed to have the court make those kind of decisions. So with that, that will conclude this hearing. We'll see you back on September 20th at 8:30. Thank you, Ms. Nemec, Ms. Kuhn.
Thank you, Judge.
Your Honor.
Have the rest of the day. Judgment.
You too.
Before you begin, Mr. Winborn, you received a fee waiver. You're on public assistance, is that correct?
I am, yes.
Okay, what type of, you appear to be young. What kind of public assistance are you on?
I'm on disability.
Okay. The reason I'm asking is there's a filing fee that needs to be addressed. Ms. Winborn, are you receiving public assistance?
Yes.
Ms. Winborn, do you receive public assistance?
Yes, I am.
What kind of public assistance?
Health insurance and food assistance.
All right. Can either of you pay the $175 filing fee?
I'm sorry?
Can either of you pay the $175 filing fee?
No, not at this time.
Well, if I give you a month to pay it?
Yeah, I could do that.
All right. How much time do you need, Ms. Winborn? It's $175. You pay that to the Monroe County clerk, and it's got to be paid in one lump sum. They won't take installment payments.
I can have it paid by the second week of September.
What about the end of August, like August 30th?
Yeah, that'll work.
I mean, it's much easier than try to pick the middle of the month. So are you agreeable then if I put in the judgment, you'll pay the $175 filing fee to Monroe County Clerk on for August 30th? It's the last Friday in August. If you can't pay it then, all you gotta do is call the court and say, Judge, I need another month. I'll give you more time. Just don't blow it off. If you blow it off, that's when bench warrants issue.
Okay.
Okay. And Ms. Winborn, if you want to contribute toward that, that's between the two of you. But the clerk, I can only order one person to do that. So the judgment, I'm going to include a sentence in here, Mr. Winborn, that you shall pay the $175 filing fee to Monroe County Clerk on before August 30th. Okay. And I'll put my initials next to that. Again, do not ignore that deadline. Okay. If you need more time, you call the court that last week of August, and I will give you more time. Just don't blow it off, please.
Yes, sir.
All right, Mr. and Mrs. Winborn, can you both please raise your right hand to be sworn, please?
I do.
Ms. Winborn? Ms. Winborn, did you hear your response?
I do.
Thank you. All right, Mr. Winborn, we'll start with you, the plaintiff. Can you please state your name and current mailing address for the record?
Yeah, Brian Jason Winborn.
Thank you. Mr. Winborn, is it true that you filed a complaint for divorce with this court on or about April 17th, 2024?
Yes, Your Honor.
Is it further true than the date you filed the complaint, you'd been a resident of the County of Monroe, State of Michigan for at least 6 months?
Yes, Your Honor.
Is it further true that you married Cassandra Jennings, now known as Winborn, on June 4th, 2016? You separated in July of 2018.
Yeah, that's correct, Your Honor.
Is it true there's been a breakdown of your marriage relationship to the extent that the obvious matrimony had been destroyed and there was no reasonable chance of reconciliation?
Yes, Your Honor.
Were there any children born or adopted during your marriage?
No, Your Honor.
Is it true you signed your name to this proposed judgment approving the terms and conditions contained therein?
Yes, Your Honor.
Thank you. Ms. Winborn, can you please state your name and current mailing address for the record?
Cassandra Winborn,
Thank you.
47.
Ms. Winborn, did you hear the testimony of your husband Brian this afternoon?
Yes.
Was his testimony true and accurate to the best of your knowledge?
Yes.
Were there any children born or adopted during your marriage?
No.
Are you currently pregnant?
No.
Did you sign your name to this proposed judgment approving the terms and conditions contained therein?
Yes.
Okay, I'm going to walk through the terms of his judgment with both of you. You both agree that spousal support alimony is not awarded. That's forever barred. You've already divided your personal property, so each will keep the personal property currently in your respective possession. There are no joint debts to be divided. Each will pay debts in their own names. Each will keep their own automobile and pay debt thereon. There's no real estate to be divided. And there are no pensions or retirement plans to be divided. And finally, Ms. Winborn is requesting restoration firm name of Jennings. Finally,
Yes.
the court's going to add a provision that plaintiff Brian Winborn shall pay $175 filing fee on before August 30th, 2024. And I'll initial that. Mr. Winborn, do you have any other questions for the court?
No, Your Honor.
What's up? Mr. Winborn, do you have any other questions for the court?
No, Your Honor.
All right, Ms. Winborn, do you have any questions for the court?
No.
And when you get a copy of this judgment, Ms. Winborn, you need to take a copy to the Secretary of State and Social Security to facilitate the legal change of your last name, okay?
Okay.
All right, so based upon the testimony that's been presented this afternoon, as well as complaint filed in this matter, the court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties be and is hereby dissolved, and judgment shall enter granting a divorce in bonds of matrimony. The court has signed the judgment. You're both divorced now. The clerk will mail each of you a true copy of this judgment in the mail. And Mr. Winborn, do not forget about that filing fee to take care of that.
I got you, Your Honor.
Okay, all right. That will conclude this hearing. You can all zoom out. Have a good rest of the day. Before the court
Thanks.
for a continued pre-trial
Thank you.
conference, the same as being conducted via Zoom. Are you Samantha Smith?
Your Honor.
Are you Samantha Smith?
Yes.
Thank you.
Yes, Your Honor.
Thank you. And sir, are you Dante Smith?
Yes, Your Honor.
Okay, when we were last before the court, the matter was adjourned so that the two of you can mediate with Mr. Walker from the front of the court. The pretrial was adjourned to today's date. The court was informed, Ms. Smith, the two of you signed a stipulated order of dismissal earlier this week. And then Ms. Smith, you then retrieved it from the clerk, and the clerk tore it up.
Yes, Your Honor.
So what's going on? We're going to proceed with this divorce action or not?
No, yeah, I'm withdrawing it.
I'm sorry?
I said I'm withdrawing it, Your Honor.
Well, you already withdrew the dismissal. What are you going to do now?
I'm withdrawing the divorce, meaning I don't want to move forward.
Okay, you both live in Dundee, is that correct?
Yes.
Come down today to sign a dismissal. We can't, the court's too busy, Ms. Smith, to go back and forth. You're making the court like a yo-yo. One day you want to dismiss, the next day you want to proceed. The next day you want to dismiss, and the next day you want to proceed. Can you both come down to the courthouse? I'll prepare the dismissal. Can you both come down today so we can close out this file?
Yeah.
I can try to come today. I can try to come today.
You're breaking up, Ms. Smith. We cannot hear you.
No, I said I can try to come today, Your Honor. I'm currently not near Dundee.
The court has a copy of the dismissal. Do you want the court just to enter the order of dismissal today?
Yes, Your Honor.
All right. So I don't want you to change your mind in 5 minutes, Ms. Smith.
I know.
Mr. Smith, likewise, you agree that this divorce action should be dismissed?
Yes, Your Honor.
Do either of you have any questions for the court?
No, Your Honor.
All right, very well. For the record, both parties having appeared via Zoom and both parties requesting the court to enter order of dismissal, the court's going to sign the copy that was retained by the court after the original was retrieved by Ms. Smith. Again, both parties asking the court to dismiss the matter. The court will enter an order of dismissal. You'll both be mailed a copy. Anything further from either one of you?
No, Your Honor.
No, Your Honor.
All right, that concludes the matter. We'll send you a copy of the order of dismissal. You can zoom out. Have a good rest of the day. Good luck to both of you. For the record, this matter is before the court for a continued pretrial conference subsequent to the parties having engaged in mediation with Ms. Patrick from the front of the court. This hearing is being conducted via Zoom. Present is Attorney Rebecca Ehrenberg, representing the plaintiff Matthew Brandes, and Mr. Brandes is present. In addition, the defendant Catherine Brandes is also present. Ms. Brandes is representing herself since her attorney Sean Glaza withdrew as her attorney of record. Good afternoon, everyone.
Good afternoon.
The court has been informed that by Ms. Patrick that the parties have reached a tentative agreement, but Ms. Brandes wishes to give it further thought or consult with an attorney before she commits to it. Is that correct, Ms. Ehrenberg?
That is correct, Your Honor. We are very close.
It's a good thing, Ms. Brandes. So you made notes in terms of what's being discussed, and certainly I think it's wise on your part to at least, you don't need to hire an attorney, but at least consult an attorney and a family law attorney to see whether or not that's a reasonable resolution. So what the court would like to do is take the proofs today, take some brief testimony just to establish that there's jurisdiction, there's been a breakdown of the marriage, there are no minor children. The court will reserve all outstanding issues, and the court will set another pretrial conference. Do you understand that, Ms. Brandes?
Yes, I do.
Okay. Ms. Ehrenberg, any objection?
No, Your Honor.
Right. Ms. Brandes, can you both please raise your right hand to be sworn, please? Begin with Mr. Brandes, please.
Yes. Mr. Brandes, a complaint for divorce was filed in this case. Did you have the opportunity to review it before it was filed? The complaint for divorce that started the case at the beginning.
Who are you speaking to?
Matthew.
This is questions to Matthew.
Yeah, I looked at it.
Okay. Were all of the allegations within that complaint true at the time of filing?
Yeah.
Are they still true today?
Yeah.
Had you been a resident of the state of Michigan for 180 days and the county of Monroe for 10 days prior to filing?
Yeah. I think I'd moved in my parents by then, so they're in Exeter Township now. I mean, maybe. But yeah, I lived in Michigan my whole life.
Okay. And you allege in the complaint that you had lived in Monroe County for 10 days prior to filing. Is that correct? Yes. Okay. Were there any minor children born during the marriage?
No.
Sorry. If the court were to not grant your divorce, would you continue to live as husband and wife?
No.
Do you believe there's any chance of reconciling?
No.
To your knowledge, is your wife currently pregnant?
No.
Okay. Your Honor, I have nothing further.
Thank you, Ms. Ehrenberg. Ms. Brandes, could you please state your name and current mailing address for the record, please?
Catherine Mabry.
Thank you. Ms. Brandes, did you hear the testimony this afternoon of your husband, Matthew?
Yes, I did.
Was this testimony true and accurate to the best of your knowledge?
No, it is not.
Were there any children born or adopted during your marriage who are still minors?
No.
Are you currently pregnant?
No.
Did you hear she objected to his?
I'm sorry, there's something that you objected to in Matthew's testimony?
Yes, he stated that he lived in Monroe County 10 days before he filed. Can you let her out? Before he filed for divorce, he did not.
Okay, did you live in Monroe County 10 days prior to his filing the complaint?
Did.
Okay, that's enough to establish jurisdiction.
Okay.
As long as one of you lived in the state of Michigan for at least 6 months and come to at least 10 days immediately preceding the filing of the complaint, that's sufficient for this court to have jurisdiction.
And I do not believe that this marriage is beyond reconciliation.
Okay, and if that's certainly understandable, but if Matthew says it is, it's a no-fault divorce state, the court must grant a judgment of divorce if in fact he remains.
That's fine, but I wanted it on the record that I believe this marriage can be fixed and worked out.
Thank you. It's noted, Ms. Brandes, and obviously Matthew has heard your position. Very well, based upon the testimony that's been presented this afternoon, the court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved according to the plaintiff. At this point in time, the court will simply reserve all standing issues and schedule this matter for a continued pretrial conference. Give Ms. Brandes an opportunity to consult with an attorney. Ma'am, how much time do you need? Do you need 2 weeks, 3 weeks, 30 days?
3 weeks would be 3 or 4 weeks would be preferable, Your Honor, since I don't have a lawyer currently and am very, very low on funds.
Okay.
I have asked Mr. Brandis to follow your order to pay for clothing and for food. And I've asked for extra money for said clothing, and he has refused every single time.
Your Honor, I'd just like to place on the record, my client does pay her $300 every 2 weeks. I have no objection to a 3-week adjournment, Your Honor. Discovery is done. Ms. Paredes did have an attorney at one point. There is not a lot to divide in this case. I don't think it needs to be prolonged too far.
All right, the court scheduled a continued pretrial conference in toward the end of August. Give Ms. Prentice sufficient time to consult with an attorney. And obviously, what's sometimes can be helpful, Ms. Amberg, you can always prepare a proposed judgment, send that to Ms. Prentice. That might assist that attorney in reviewing the terms of the judgment.
Absolutely, Your Honor.
So you can put together just a draft proposed judgment. That might be the easiest thing for Ms. Prentice to take to an attorney. That's what he suggests.
I have Thursday, August 29th at 1:30 or 2.
How about the Thursday, August 29th in the afternoon?
That works for me, Your Honor.
That sounds fine.
Okay, is there any need to meet with Ms. Patrick any further, or will you simply going to appear before this court on that date for a final pretrial? Do we need to meet with Ms. Patrick any further on that date?
I don't think that would be necessary, Your Honor. I'll let Ms. Brandis answer for herself.
No, I don't think we need to meet with them again. I think just the August 29th should be fine.
August 20th at 1:30, and the court suggests Ms. Amberg again to prepare a draft judgment, send that to Ms. Brandis. Maybe she'll talk to the attorney and have a approved judgment when we come back April 29th.
That's a good idea, Your Honor. I'll do that.
All right, thank you. All right, the court will mail out a notice to Ms. Ehrenberg as well as to Ms. Brandis, August 29th at 1:30. Well, then there'll be a Zoom hearing once again. Thank you, Ms. Patrick, for your assistance.
You're welcome, Your Honor.
All right, that will conclude this hearing. You can all Zoom out. Have a good rest of the day. Court's recollection is that on July 25, the parties mediated with Patrice Patrick from our friend of the court. The court's notes indicate that a tentative resolution was in place with the defendant. Catherine wanted to consult with an attorney. Court took proof at that time and adjourned the matter to today's date. Ms. Brandis, have you consulted with an attorney?
I was unable to afford one, Your Honor.
Okay, you can represent yourself then?
Yes.
Okay. Ms. Ehrenberg, have the parties exhausted all efforts to reach their own agreement?
Your Honor, I believe so. We've had many conversations back and forth. We've been very close a number of times, but we've just not been able to settle.
I believe the only thing we have left to agree on is the length of the payment.
Well, Your Honor, if we go to trial, everything's going to be at issue.
If we have a trial, the Mr. Brandis spouse support obligation is open-ended.
I understand that, Your Honor.
There should be some merit, some desire, natural desire on the part of the husband to cap that, Mr. Ehrenberg. Otherwise, it's going to be open, modifiable.
And Your Honor, that is what I'm trying to do. That is not what Ms. Brandis will agree to.
Well, she just said something about you got agreement, everything except a cap on the spousal support.
No, she means the length of time of the payment, but she does not agree to make it non-modifiable. At least she hasn't.
Actually, I did. That was one of the things that
All right, I'm going to have you talk with Mr. Walker. It's all like the parties have not concluded, fully exhausted their discussions. And Ms. Brandis, I will tell you, we throw things up there at the trial, everything's at issue. You have no control. The court will decide everything. In terms of personal property, you could liquidate everything. So I'm going to have you and Mr. Brandis and Mr. Ehrenberg talk again with Mr. Walker in front of the court. See if you can put out your proposal and see whether you can come any closer. Okay. Mr. Walker, are you still available? Mr. Walker, I don't think the parties in good faith have exhausted some discussion. So if you could spend some time and talk to them again this afternoon before we schedule a trial date, please.
I can do that.
Thank you. I just conferred further with Josh Walker from the front of the court, and the court has been informed that the parties have in fact reached their own agreement on that room. Won't remain an issue of spousal support. Is that correct, Ms. Ehrenberg?
That's correct, Your Honor.
Wonderful. Is that correct, Ms. Brandis?
Yes.
Okay. The court's going to have Ms. Ehrenberg state the full agreement on the record. So listen carefully, make notes, because after she does so, I'm going to turn to you and ask whether or not it's an accurate statement of your agreement. Okay?
Okay.
And do you understand if the court adopts this agreement this afternoon, there will be no trial? just a matter of just reducing all to writing in form of judgment. You understand that?
Yes.
Okay, and obviously you've had the opportunity to consult an attorney, maybe not hire the lawyer, but at least consult an attorney. Is that correct?
No, I haven't been able to speak with anyone, but I agree.
You've had the opportunity.
I had the opportunity, yes.
Okay.
I had the
That's the
opportunity.
question. All right. All right, Ms. Ehrenberg, if you could kindly please say in the record what you understand to be the parties' full agreement, please.
Yes, Your Honor. The parties have agreed to spousal support to be paid by Mr. Brandis to Ms. Brandis in the amount of $1,000 per month for a period of 8 years. That will be non-modifiable. The parties have also agreed that Ms. Brandis will be awarded half the marital portion of Mr. Brandis's 401k. Ms. Brandis will be awarded the marital home, and that is located at, she will keep all of the equity in that home. In exchange for that, the parties are each going to pay their own attorney's fees. Ms. Brandis had a previous attorney that she paid for. The parties will keep their own bank accounts, they will keep their own debts, and they will keep their own vehicles.
With respect to the spouse support, non-modifiable, is it non-modifiable in terms of amount as well as duration, Ms. Ehrenberg?
Yes, Your Honor.
Is that correct, Ms. Brandis?
Yes.
So you cannot ask for an increase. Mr. Brandis likewise cannot ask for a decrease in terms of the amount or the duration. Understood?
Yes.
Yes.
The quadro, will the parties share in the cost of that qualified domestic relations order, Ms. Ehrenberg?
They will, Your Honor. They will split that cost.
Share the cost of the preparation as well as any fees that charged by the plan administrator. Is that correct?
Yes, Your Honor.
You understand that, Ms. Brandis? It's turned about $500 to prepare a quadro, so the two of you will share that equally.
Yes, Your
Pretty
Honor.
standard. Okay. Again, with those clarifications, Ms. Brandis, did Ms. Ehrenberg accurately state your agreement?
Yes, she did.
Oh, Mr. and Mrs. Brandis, can you both please raise your right hand to be sworn, please? The court would note that the proofs were taken back in July, so that's been established. The court will simply update the proofs for Mrs. Ehrenberg. She's not now pregnant, but if you can simply warn dear Mr. Brandis relative to the terms of the settlement agreement, please.
Thank you, Your Honor. Mr. Brandis, did you hear the settlement agreement as was placed on the record?
I did.
Do you understand all of the terms of that agreement?
Yes, I do.
Does it accurately reflect your understanding of what the agreement is?
Yes, it does.
Do you understand that you had a right to trial in this matter?
Yes, I do.
And at trial, the judge could have ordered better, worse, or exactly the same as this agreement. Do you understand that?
I do.
And do you wish to waive your right to trial in order to enter a consent judgment that comports with this agreement?
I do.
Your Honor, I have nothing further.
Thank you, Ms. Ehrenberg. Ms. Brandis, can you please state your name and current mailing address for the record?
Catherine.
Thank you. Ms. Brandis, are you currently pregnant?
No, I'm not.
Thank you. Again, the settlement agreement placed upon the record, have you entered into that freely and voluntarily?
Yes.
Has anyone promised you anything or threatened you in any way in order to get you to come to that agreement?
No.
And once again, you understand that there will be no trial. The court will simply, this agreement will be incorporated into judgment of divorce.
Yes.
Do you have any questions for the court?
No, I do not.
Okay. Ms. Ehrenberg, you'll prepare the judgment. Will you submit that to Ms. Brandis for her review and approval, or will you submit that under the 7-day rule?
Your Honor, I will submit it under the 7-day rule. I think that will probably be the most judicious.
All right. So Ms. Brandis, Ms. Ehrenberg is going to prepare a written judgment of divorce. Look for you probably get that in the next, probably within the next week or 10 days. Look at it carefully. Make sure it accurately reflects your agreement. If there's an issue, call Ms. Ehrenberg. And there's going to be, with that judgment, there's going to be a notice saying if there's anything in judgment you object to, which if something's in there that you didn't agree to, you need to file a written objection with the court. And then when the court receives written objection, the court will schedule a matter for hearing. So again, before you do that, call Ms. Ehrenberg and just say, you know, maybe there's a typo in there or something that that she needs to modify.
Yes, Your Honor.
Okay. Again, Ms. Brandis, do you have any questions?
No.
All right, Ms. Ehrenberg, do you have any questions, Ms. Brandis?
No, Your Honor.
Very well, the court would like to thank and acknowledge Mr. Walker for his assistance, as well as, of course, Ms. Ehrenberg for helping facilitate resolution. The court would applaud the two of you without question. The best resolution is one in which you both participate. There's always certain risks associated with trial, uncertainty associated with trial. The best resolution in the matters of this nature is one in which you both participate, as you have. So the court applauds you for that. Ms. Brandis, do you want your former name restored, or are you going to keep the name Brandis?
I'm keeping Brandis.
Okay, that was one last thing I forgot to ask. Very well. Based upon the testimony that's been presented this afternoon, as well as the complaint filed in this matter, the court defines again that jurisdiction has been established and that there has been a breakdown of the marriage relationship to the extent that there's obviously matrimony been destroyed and there's no reasonable chance of reconciliation. Calling upon receipt of the judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved. Judgment shall enter, granting a divorce from bonds of matrimony. One last question, Mr. Ehrenberg. When does the spousal support commence? Will that commence on September 1st, October 1st?
I believe that will commence October 1st since the September 1st is in 2 days. I don't want to start him in the hole.
That makes sense. So, Ms. Branch, you understand that spousal support will begin on October 1st. And that'll be through uniform spousal support orders. Is that correct? Paid through the front of the court?
Yes.
All right. So you understand, Ms. Brandis, your first spousal support payment of $1,000 will be received on September 1st. I'm sorry, October 1st, because September 1st is right around the corner.
Yes, Your Honor. Will he continue with the agreement we have in the month of September, or do I need to pay all of the bills myself?
Good question. Presumably the status quo would continue until the judgment is entered. So would you agree that the status quo continue until the end of September?
Yes.
Okay. So yeah, that's a good question, Ms. Brandis. Yes. And whatever Mr. Brandis has been paying in the past, that will continue until the end of September.
Okay. Thank you.
Okay, you're welcome again. Good luck to both of you. Without concludes here, you can all zoom out and have a good rest of the day and weekend.
Thank you, Your Honor. You too.
Welcome. Ms. Galvin, you need to turn on your audio.
Tienes que poner tu volumen.
Oh, ¿le subo? ¿Se me escucha ya?
Yeah, we can hear you now.
For the record, this matter is before the court for a continued pretrial conference. The same is being conducted via Zoom. The parties have mediated with Mr. Josh Walker from the front of the court this afternoon.
Okay.
Present is attorney Monica Brinkman representing the plaintiff Juan Galvin. Mr. Galvin appears to be present with Ms. Brinkman in her office. In addition, attorney Reina Diab, is it pronounced Diab? You're muted, Ms. Diab.
Oh, can you hear me, Your Honor? Yes, it's Diab.
Ms. Diab is representing the defendant, Mary Galvin, and Ms. Galvin is present. In addition, we have an interpreter, Mr. Eric Nisani, is that correct?
Yep.
Thank you, Mr. Nisani, for your assistance and availability this afternoon. Ms. Brinkman, were the parties able to reach your own agreement?
Yes, Your Honor.
Okay. So perhaps we can place that agreement upon the record. Mr. Nisani can repeat that agreement. The court can confirm with the parties that that's their agreement, and then the court will swear the parties in. We can take some testimony.
Yes, Your Honor.
So again, if you could proceed with stating what you understand to be the parties' agreement.
Yes, Your Honor. Thank you. The parties will share joint custody of the 3 minor children and equal parenting time. The parenting time schedule will be liberal, flexible, and meet the needs and schedules of the minor children. The parties will also mutually agree on holiday parenting time. Child support will be paid pursuant to the Michigan Child Support Formula. At the time of this hearing, the calculation is approximately $1,500 a month for support of the 3 minor children. Mr. Galvan is going to provide and maintain health insurance for the minor children through his employment. Mr. Galvan is not awarded any spousal support and is waiving and barring any right to petition the court for spousal support in the future. Ms. Nahara is awarded $700 per month for a period of 5 years in non-modifiable support. That will commence August 1st, 2024. Ms. Nahara is awarded the marital home on Mr. Galvan has the option of exercising a 5-year lease on the apartments, barn, and equipment storage buildings that are located on the real property. Mr. Galvan will maintain the property taxes, insurance, and the utilities, including the marital home, on the marital home property as long as he is residing in or exercising his lease. If Miss Nahara decides to sell the property, the marital home, Mr. Galvan has a right of first refusal to purchase it from her at fair market value. The parties own a home in Texas. Mr. Galvan is awarded the home in Texas. That property does have a mortgage currently that Mr. Galvan pays each month. The mortgage is in Miss Nahara's name alone. Mr. Galvan will continue to make timely payments on the mortgage and will obtain a loan, a personal loan by him, and pay off the balance of the mortgage within 6 months of the entry of the judgment. When the loan is paid off, Miss Nahara will execute a quitclaim deed or whatever's required in the state of Texas and will deed 100% of her interest to Mr. Galvan. Each party.
Y ahí cuando él va a firmar para, perdón, tengo una pregunta. ¿Y él cuándo va a firmar para transferir esta propiedad a mi nombre?
When would she be having to sign her? I'm sorry. When will that signature be needed to transfer the property to his name?
Once the loan is paid off in full by him.
La propiedad de aquí de Texas, ¿cuándo se va a cambiar el título solamente a mi nombre? La propiedad de aquí de Michigan, la que ya está pagada.
Como no entiendo. Let me clarify.
Esta propiedad en la que vivimos ahorita, nunca se habló de cuándo la va a poner a mi nombre nada más.
Yeah, he says that she's just saying that he wants her to transfer her interests in the property in Texas, but we never talked about when the property in Michigan will become in her name.
Oh, he will and I apologize. He'll execute a quitclaim deed within.
I don't know when whatever we have to do.
Upon entry of the judgment. I mean, Miss Deb, you can state whatever date you want to put in the judgment.
I think.
Yeah.
I don't know why I'm saying this.
Oh, no, okay.
Okay. Yes, upon entry of judgment. So
each party is awarded the property in Mexico that is titled in his or her individual name. There is no other real property to divide. Each party is awarded their personal effects. Miss Nahara is awarded the contents of the marital home. Mr. Galvan is awarded the contents of the Texas home. Miss Nahara is awarded the 2015 Dodge Ram truck. Mr. Galvan is awarded the 2004 Dodge Ram. Miss Nahara is also awarded the Toyota. Neither party can recall the make or model of the car at this time. Mr. Galvan is awarded 100% of his interest in Nahara Brothers Cement. All of the equipment owned by the company is property of the company. If there is any equipment that is not owned by the company but is entitled in Mr. Nahara's name, Mr. Galvan's name, that is awarded to him. On January 1st, 2025, Mr. Galvan will determine the net proceeds of the business. We are defining net proceeds as the profit of the business after taxes have been paid, liabilities have been paid, any employees have been paid, the final profits for the calendar year 2024. Mr. Galvan will pay Miss Nahara 1/2 of that number. Each party is awarded any bank accounts in his or her name. The joint checking account ending in 9887 shall be divided equally and closed. There are no retirement or investment accounts to divide. There is no joint debt to divide. Each party will assume any debt in his or her name.
Ms. Richmond, I just wanted to add, instead of waiting at the end, that except for the debt that's associated with the mortgage, which is Mr. Harrison, that was the debt, So if we can just have something in there, say that.
Absolutely. I'll clarify for the record. There is no debt other than specifically described on this record regarding the mortgage on the Texas home, there's no other debt other than that specifically stated to divide.
Yes.
That is the agreement, Your Honor.
Thank you, Ms. Brinkman. The court had two questions. Is Mr. Juan Galvin, is he the sole owner of the Jarrett Concrete business?
Yes, Your Honor.
Okay, another question. Mr. Juan Galvin has a 5-year use of the apartment and the barn on the Sumter Road property. And during the period of time, he'll maintain certain expenses. What if he leaves before the expiration of the 5 years? Is he obligated to only pay those expenses while he continues to occupy the property?
Only while he continues to occupy the property.
All right, so if he leaves after 2 years, his obligation to pay for insurance and so forth will terminate at that time.
That is correct.
I'm sorry.
Clarificó el juez que si,
Is that correct? I'm sorry, we didn't get your response, Ms. Brinkman?
Yeah,
Okay,
yes, that is
that's
correct, Your Honor.
Thank you, thank you. Ms. Diab, did Ms. Brinkman accurately state your client's agreement?
Yes, Your Honor.
Thank you. Mr. Galvin, Mr. Jarrett, can you both please raise your right hand to be sworn?
Yes, yes, we do.
Speak up real loud.
Yes, we do.
Easy.
Mr. Jarrett, see?
Yes, we do.
Thank you. All right, Mr. Brinkman, if you want to proceed with the proofs from Mr. Galvin, then confirm with him his understanding of this agreement, please.
Yes, Your Honor. And just briefly for the court's awareness in the record, I addressed this with Mr. Walker. We've had discussions about the parties potentially entering a judgment of separate maintenance. Mr. Galvan is consulting with an immigration attorney and is going to get a written opinion as to whether or not the party's divorce could impact his status. He is currently in the process of obtaining his green card and is just awaiting confirmation. It is not conditioned or necessarily tied to Miss Nahara's name. He did not apply, or she did not apply on his behalf. However, the parties have discussed this, and so I just want the court to be aware. I can do the statutory proofs for divorce, and then if the court allows it, if the parties then agree to enter a separate maintenance judgment in alternate of judgment of divorce, is that okay with the court?
Absolutely. Yes, it would be.
Thank you. Thank you, Your Honor.
I'm just going to interpret the
sorry.
And just to clarify, this is a separate maintenance judgment, not a divorce, and that you will he's in the process of getting a work permit, and he's wanting to consult with his immigration attorney about that. And Miss Nahara has nothing to do with the immigration issue. Did I say that correctly?
The only correction I have, sir, is that he's not applying for his work permit. He's applying for his permanent residence.
Oh, permanent resident.
Right. And so he's working here. He is here legally.
Okay.
It's just the final green card status. So I just want to make sure that's
green card status. Okay. I'm not sure if I missed that. Getting lost. I said, yeah, basically, I don't know if I meant that the immigration consultation with his lawyer is going to take place, and she has nothing to do with it. It's just something he's doing separately, and that during this time they're fine with the separation maintenance agreement instead of a divorce. Did I miss something? I apologize. That's about it.
I believe that's the gist of it.
Yeah. Okay.
Mr. Galvan, when you filed your original complaint for divorce, had you been a resident of the state of Michigan for at least 180 days?
Yes.
You have to speak up nice and loud for me.
Yes.
Had you been a resident of Monroe County for at least 10 days?
Yes.
And do you understand that although you filed I'm so sorry.
That's okay.
And although you filed a complaint for divorce, you understand that we may be entering a judgment of separate maintenance. Do you understand that? You can say yes. Okay. Did you hear the agreement that I read into the record?
Yes.
Did you understand the entire agreement?
Yes.
Is that the agreement that we came to at mediation and leading up to mediation today?
Yes.
Do you believe that the custody and parenting time is in the best interest of your children?
Yes.
Do you understand that you are waiving your right to ask the court that Miss Nahara ever pay you spousal support? Do you understand that the property settlement is final and binding and you cannot come back to court and ask the court to change it later?
Yes.
Understanding all of that, are you asking the court to enter a judgment that separates all of your assets and determines custody and child support?
Yes.
Will you ever continue living as husband and wife with Miss Nahara again?
No.
And just in case we do a judgment of divorce, just for the record, if we enter a judgment of divorce instead of separate maintenance, actually I just got that. I'm sorry. Never mind, strike that. I'm satisfied, Your Honor.
Thank you, Ms. Brinkman. Ms. Diab, do you have any questions of Mr. Galvin?
No, Your Honor.
Questions for Ms. Nahara, please.
Yes, please. Ms. Nahara, you heard the terms that were placed on the record for custody and property, correct?
Yes.
Do you believe that the custody and parenting time provisions are in the best interest of your children?
Okay. Yes.
And you understand that the property terms are non-modifiable, so they're final. You can't come back to court and ask the court to change anything regarding property. Do you understand that?
Yes.
And you understand that the spousal support that you will be receiving is for 5 years, and you can't come back and change the amount or the time that you will be receiving support. Do you understand that?
Yes.
And do you agree with all of the terms that were placed on the record? Do you agree that this is what you want the court to enter?
Yes.
And that this is a judgment of separate maintenance debt and not divorce that we were discussing. Do you understand that?
Yes.
Okay. And you're asking the court to enter a judgment in accordance to the terms that you heard Ms. Brinkman state?
Yes.
I'm satisfied, Your Honor.
Ms. Nahara, are you currently pregnant?
Señora Najera, ¿estás embarazada ahorita?
Thank you. Ms. Brinkman, do you have any questions for Ms. Nahara?
No, thank you, Your Honor.
So, Ms. Brinkman, you'll prepare a judgment of separate maintenance, or if there's no issues with immigration, then you'll prepare a judgment of divorce. Is that correct?
That's correct. If that's what the parties' agreement is, we will adhere to the parties' agreement and based on the advice of counsel.
Thank you.
Thank you.
Well, the court would like to thank Mr. Walker for his assistance in facilitating resolution this afternoon, as well as, of course, attorneys Brinkman and Diab for helping facilitate ample resolution. The court would applaud to you, Ms. Nahara and Mr. DeGallo, for reaching your own agreement. Without question, the best resolution is one in which you both participate. It's wonderful you can co-parent your children. That's huge. The court would also like to thank Mr. Nasani for his assistance, fine assistance helping interpret this afternoon. Based upon the testimony that's been presented, as well as claim filed this case, the court finds jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the object of matrimony has been destroyed, and there appears to be no reasonable chance of reconciliation. Calling upon receipt of the judgment of separate maintenance or judgment of divorce, the court will sign that, and at that time, or that the marriage between the parties be dissolved, or that the court would incorporate into the judgment of separate maintenance all these binding terms that have been placed on the record. And you'll prepare that to judgment, Ms. Brinkman, is that correct?
Yes, Your Honor.
Wonderful. All right. If there's nothing further, everyone can zoom out. Have a good rest of the day, and thank you all.
Thank you so much.
Stop the clock. That was really painful.
No, it takes a long time.